Hi there. Welcome to Para 310, Introduction to Trial Presentation. My name is Shannon Bales, and I'll be your instructor for this class. Um, During the day, my day job is working as a manager at the law firm of Munger, Tolles and Olson, where I manage the litigation support department with 13 people. The majority of those people are e-discovery project managers, two graphic artists, and two trial hot seats. We'll be focused in this class on the role of the trial hot seat, doing great trial presentation, and some of the philosophy behind how to do it right and what you need to do to be a superstar in this area. Um, Nobody on the trial team gets more positive attention than the hot seat. They're the heroes of the trial team. It's not always fair as a manager of a group that has a very diverse skill set. We can have one of our e-discovery project managers work on a case for years, put in long hours, and then hand it over to a trial tech who goes to court and helps an attorney present and win at trial for a week with a couple of late night hours in there. And who gets the greatest kudo email in the world? The trial hot seat. So life isn't fair, and but the work of a trial hot seat is very demanding, um, but it's also very rewarding because you do get a lot of praise by the legal team, and rightfully so. The hot seat is the center of all presentation on the trial team, and um, prepares everything that is going to go up on the screen by the attorney and makes sure that it comports with the courtroom standards on how exhibits are branded and the format of the exhibit and all of these things we're going to be talking about in the class. The trial hot seat also evaluates the courtroom and finds out what kind of tools they need to better present at trial. Um, it, uh, we typically work with trial presentation vendors who rent equipment to us. We'll talk about equipment as well in a later chapter. Um, but basically, the hot seat ties everything together from all the different sources of information, exhibits, video, transcripts, and then practices in a perfect world with the attorney that's presenting for the day. And I say presenting for the day because you might work on a team with multiple attorneys um, to refine and hone that presentation so that it looks like 60 Minutes or a TV news broadcast. When they call out an exhibit, when the attorney calls out an exhibit, does it just show up on screen instantly within seconds? When they play video, is it smooth? Has it been cut and edited in a professional way? And these are all the things that a good hot seat does. Really, they're the focal point of on the support side of where all the workflow is going to, because everything is basically getting prepared to present at trial. Um, Now, let's talk about chapter one, and we'll talk extensively throughout this course about the hot seat and supporting the hot seat and what the hot seat does. But really, we're going to be going through my book quite a bit and talking about how to best present, what are the standards, what are some of the best softwares to use, what kind of equipment do you need. Um, and really, a lot of this came out of seeing problems at trial law firms experienced when they went to trial. They didn't have the right equipment. They didn't have the right support. Um, you know, Oftentimes, the hot seat might be tasked with doing tasks unrelated to presenting a trial, and in some situations that's okay. But if you're a paralegal wanting to do some trial presentation work, which I highly encourage you to do, you have to put on your trial presentation hat and not your paralegal hat, because if you're trying to balance 20,000 other tasks that are happening at trial, And then as kind of a aside, people say, "Oh, and by the way, you do that easy trial presentation as well. You're going to get embarrassed. You're going to get embarrassed in the courtroom because someone else is going to come ready to play, and they'll have the equipment ready, and they'll have good equipment, and they will have practiced with their team, and the exhibits will be in the right format, and they will have received the exhibits, and they have tracked them, so everything ends up showing up, and the timing is right, and then you look redonkulous." Okay, let's jump into it. So I start with, if I had 8 hours to chop down a tree, I'd spend 6 hours sharpening my axe. That's a quote by Abraham Lincoln on preparation. And with trial presentation, everything is about the preparation. Everything we do. Because the easiest part to do is to type in an exhibit number and have it show up on screen. What's not easy is getting the equipment and making sure it works, and making sure it works every day consistently, and that you have a backup and all these things, which we're going to talk about. But truly, putting the exhibit up on screen is easy, even though there's a lot of eyes on you and it makes you nervous and that kind of thing. But a lot of teams make the mistake of not really understanding that trial presentation environment. Every courtroom is different. So what that means is that you have to tailor your presentation for that particular courtroom and make it so that the judge is happy, your jurors are happy, your clients are happy. And a lot of teams will do, for example, they'll create a PowerPoint, and the PowerPoint looks fantastic, but they didn't tailor that PowerPoint for use on a screen that might be 20 feet on the other side of the courtroom. They didn't understand their presentation environment. And so they can't read. As a result, nobody can read the text that's on the screen. So having gone to the courthouse ahead of time and measuring that distance and figuring out if they can indeed see the font from the other side of the courtroom is something that's a huge differentiator. And I can't tell you how many teams I've seen just blow it from the beginning because nobody can see their $100,000 presentation from across the room. Okay, so why are we there in the courtroom? What gets us in through the door? And you may think like, you know, every legal team is just raring to get this technology person in there to help them, and to an extent, it's true. You know, there's really good relationships typically between the attorney and the hot seat, and the legal team and the hot seat. But the real reason that we're there is to aid in courtroom efficiency. Putting those exhibits up on screen saves time. So if you have one attorney or 20 attorneys and they're all burning at $500 an hour or $2,000 an hour, and that hot seat saves a quarter of the time of a trial. So in a 1 week trial, one of the days is saved because the hot seat is going to save the time and aid in the understanding. You really that's the reason why we're there, because otherwise the judges don't want you there. You're a pain in the butt to be in the courtroom to set everything up. The attorneys and clients don't want to pay for you because you charge some exorbitant rate. I think market as of this video is $250 to $450 an hour for a good trial presentation hot seat. But you're there for efficiency. You're there to get things up on the screen. And what does that, what's the comparison? The comparison is that I have an exhibit and I have to pull a paper copy out of a binder. I have to find it. I have to find the paper copy. I have to walk it up to the judge, get the judge to say it's okay, walk it over to the opposing counsel, make sure they're okay with it, and then pass it around, or show it from the middle of the courtroom or on a overhead projector or something like that. And think about how much time that takes, walking over and doing all this stuff and pulling it out of the binder and then showing it around. That might take 10 minutes, let's say, for one showing one page, you know, I can put anything up, video, exhibits, anything up in, you know, within 2 seconds of being asked, just by putting in the exhibit number into our trial software. Um, so the reason that we're there is to aid in that courtroom efficiency, and if as a byproduct you help your attorneys be more persuasive and win their case because you're more professional and you present better and you have better exhibits and better quality and you zoom in better and really help the attorney present their case, then you're persuasive, right? So there's efficiency. The court wants efficiency. Attorneys want persuasiveness, um, and um, that's why hot seats get in through the door. I mean, I have lots of stories about, you know, who sits at that front table, who sits at counsel table, and I'm often asked, you know, as the hot seat to sit at counsel table right next to the lead attorney, and you know, that irks a lot of attorneys. You know, why are you here? I'm the attorney for XYZ law firm. Why are you sitting at this table? Because I'm the hot seat and I'm going to present the exhibits. Now, sometimes we set up a table somewhere else in the courtroom, but lots of times, you know, you want to be sitting very close to whoever the attorney is that's presenting, or to be able to show them some exhibits and not have it on the screen and that kind of thing. You know, it's potential to ruffle some feathers. All this goes into taking your trial obligations seriously. What that means is when you or your firm have been asked to go to court, you know, that you have done adequate planning for the courtroom environment, that you have the right equipment, that you have the right training, and you know, if any of those things are missing, you risk a potential dumpster fire that affects your firm's reputation, the attorney's reputation. Professional hot seats know that affects their reputation as well. So if you're a part timer, you know, the negative effect that you can have on the outcome of your case due to unprofessional behavior or not having the right equipment or any of those things really is a risk. And so you know, you have to navigate that as you're deciding whether to take on the trial or not. Some trials are small enough to where, and I hope everyone gets their opportunity to like this, but some trials are of a size where there's some flexibility and you have a, you know, a nice judge or clerk that's forgiving, and you know, it gives you that opportunity to do this. But a lot of us were just thrown into it. My first trial presentation was I was handed the manual to the trial software and said, be ready tomorrow morning to present this at the courthouse. And I read the manual and I figured it out, and I showed up at the trial, and now I write books on that. You know, what happens is that another thing that happens is, you know, not having the right firm support for the right kind of equipment. Law firms are often reluctant. It's a really bad decision making on their part, but really reluctant sometimes to buy the heavy duty kind of gaming laptop. They hear the word gaming laptop and they don't want to get it because it's a gaming laptop. But those gaming laptops often have very strong video cards and that kind of thing that allows them to present well. And we'll talk more about equipment later, but you know, coming in with the right equipment, with a plan and all that, gives everyone on the team confidence that you're going to present right. And so all this preparation is time well spent. Along with that is you know, your preparation is, you know, gets everything, you know, gets you through the door and you're ready to go, and gives a lot of confidence, as I just mentioned. So I mentioned a little bit why do we use trial software? You know, again, it's that efficiency that the software brings, the ability to put up any exhibit that you have, that you put it all in the system, and any exhibit you have goes up, and that ability for you to pick up any exhibit in any order, any page, and to annotate it um, really is a huge differentiator for efficiency. And if you're good at following the lead of the attorney and what they're talking about, you know it really does help on the persuasive side as well. Um, the two main trial softwares that are out there are OnCue, ONCUE, and Trial Director. OnCue has really taken over the industry. It's really well thought out. It has a lot of fantastic features. I think for someone who's a more casual user, it is a little bit complex. So Trial Director, which is also a really good trial present software, but I think Trial Director is better for basic users, newer users, and OnCue is better to use when you're really familiar with your equipment and video editing and all those features. And the reason why, one other reason why we use trial software is, people will say, why didn't you just create a PowerPoint? Well, can you imagine? Do you want to create a PowerPoint slide for every conceivable page for every exhibit that you have? It'd be impossible. You just can't do it. So typically we're using a combination of PowerPoint and the trial presentation software for our openings and closings and maybe witness examinations. So we're limiting the amount of slides, although that's a project in itself, which we'll talk about. When I say limit, these opening decks can still be 200 or 300 slides long. Closing, same thing. So we're working on getting that, figuring out, what needs to go into a PowerPoint and what can just be displayed and presented on the fly in the courtroom. So, if you look at this kind of from a risk management perspective, which is 1.4 in the chapter, you're really looking at preserving the firm's reputation. You're looking at, being persuasive attorneys at trial. And so law firms that get it have legal team involvement, technician involvement. Everyone's talking to each other. The team is empowered to help, meaning there's training and we know what's going to happen at the trial support. By the way, I think one of the most fantastic careers out there might be the person who, in very large firms, who figures out the trial site and the lease and all that when you go and they create what's called a war room, which is a big room, the legal team. So taking a step back, when the legal team goes to trial and it's a big legal team, they might rent out the entire floor, or even a couple of floors at a hotel, and we convert some of those rooms often, or even get temporary office space called a war room. And because we don't like to have, all of our, we don't want to do all of our work in our hotel room, and we certainly don't want people coming in and out of our hotel room to work together. So we create what's called a war room, and we pull all the beds out of the room, and open all the doors between the rooms in some cases, or we get a meeting space at the hotel, or sometimes we even rent office space temporarily at an office building. We bring in the printers, we bring in computers, monitors, catering, laundry, you name it, if it's a case of size, and do all that so that we can go to trial and win the bet the company litigation. As paralegals, where this class is helpful is that, one, maybe you end up becoming a hot seat and doing hot seat work for your firm, but also number two, you might want to, you likely manage a hot seat at some point in your career. And as someone who's been who is the hot seat, the trial presentation person, great teams understand that the hot seat needs to get all their files and their information, and that it flows to them, and that managing paralegal is finding ways to do that and support the hot seat. Paralegals that get it wrong are out there saving their own butt, jealous of the relationship between the hot seat and the attorney and that kind of thing, and are having the hot seat, print out their binders for them and do all these other things rather than focus on the trial and getting those exhibits ready. And then last, making sure you have managing the risk means that you have the right equipment and software. And I did mention before, wearing too many hats is not a very good idea. Now, how do courtroom issues occur? You're going to go to court and you're wondering, how do they occur? And the first one is that you don't have the skills needed to present. So we hope to kind of change that through this class. But you got to practice, you got to do all the things in court that you need to do. You need to have the appropriate training and how to configure the equipment and plug it in and test it and have a backup, and how do you move the equipment, change to the backup and all that kind of stuff. And you'll hear that as a common theme, having the right equipment. When you don't do a site visit in advance is one of the predictors of courtroom failure. Every court site is different. Every courtroom is different. The people involved, the process to bring your equipment into the courthouse. You might need a judicial order. You might need something like that. So visiting the courthouse ahead of time, or telling your attorneys to find out what the rules are for bringing in equipment. Some courtrooms we bring in everything: monitors, projectors, printers, you name it. And some courtrooms, courtrooms are improving, and some are equipped really well. But there's rules about how you get the equipment into the courtroom, and you got to know that. And then you got to have a discussion with the clerk about where do they want the equipment, where do they want you to sit, all of that. You'd be surprised how many people come in and they just throw equipment down on the ground and do whatever the heck they want. And it's just awful. Some of the awful things that I've seen. I've seen paralegals walk in and start taping down their equipment, and they're using what is it? The packing tape, right? The clear plastic packing tape, and they're taping down their cables on the courtroom desk, and what that means is, as soon as you come and rip it off, you're going to rip all the varnish off the table. I've seen people use that kind of tape on the floor and have them pull up the tape and literally a giant section of carpet come up with it. We use a special gaffing tape, the kind that the rock stars use to tape down their cables, and we use that kind of tape to so that it doesn't leave a mark, and it doesn't leave residue, and it doesn't stick so hard that it rips everything off. And so that's something that occurs. Other times, if you haven't practiced with your team, that's a predictor of failure, because we review the outlines and want to be on the same page with the outlines, so we know how the attorney will call out exhibits, and have that communication well understood prior to going into the courtroom. And there's a lot of miscommunications around that lead to major problems. Like the attorney often will have an outline. They might have old deposition numbers, not the exhibit numbers. They may have it put in there by name, like, pull up the contract. Okay, well, I don't know what the contract is. Tell me the exhibit number, right? Other times, people have dropped their equipment or stolen or that kind of thing, and they don't have a backup. We're going to emphasize a lot in this class about having a backup. And then, last I'll mention, when you have a major opportunity for your firms that don't have this in place. And I'm not saying that every firm needs to have their own hot seat. So what I mean are policies and procedures in place for you either to manage that hot seat, or to from a third party vendor, or to have that hot seat in house. When you don't have procedures around it, things break down. If the help desk doesn't prioritize um, trial requests over routine requests coming in, there's going to be problems. If there's um, no rules about updating the equipment or being within the security posts, all these little details um, present opportunities for you as paralegals to either manage that group or create a great trial environment for your team. And so we're going to be talking about that throughout this class. I'm looking forward to teaching this class, and if possible, meeting some of you, all of you. And my door is open if you want to have a discussion about what you're learning, or you have a question. My phone number and email are provided. So welcome to the class, and I'm looking forward to this semester. Thank you.